Yes, sir. Okay. Of index one, I'm using Ms. Hilton's email for purposes of this discussion.
And Your Honor, it will be State's Exhibit 401.
I was gonna ask you that
Yankee.
next. Okay, it will be, States 401 Yankee.
Yes, Your Honor.
And Mr. Steele, what's the part that you have an objection to?
Mr. Copeland is asking for a lawyer. I believe the state alleges that he's speaking with Mr. Jeffrey Williams for part of that call at about that time, and that Mr. Williams uses my name, my first name, on the call. I would object and ask to redact that portion, especially my name.
Okay.
Your Honor, in listening to that call, I don't believe he said Brian.
Can you
And
play
we'll
it?
play. What's the time?
Can you play the
span?
maybe play the last 2 minutes? That'd be sufficient for me to listen to it, Mr. Steele?
Yes, sir.
Okay. Let's play the like 13:30 to the end.
Okay.
Okay, of 15:30. Oh, thank you. Thank you.
Oh, sorry, that's not the right one.
Hey, wait.
You go.
13:50. Okay.
Look in your eyes. Yeah, they say.
Your Honor, we're gonna start at 13:30 or 13:33 now.
The police, let them jump on me. I speeding it crazy, man. Man, whoever has so many problems, and whoever in the jail, all that jumping, that what's your intent, man? What's your intent, man? This shit here a drag, bro. Man, what the hell you talking about? You already know I know what's happening. Some of y'all know, I already like what the hell, what they talking about. Man, I'm talking about nobody. That's what I'm trying to tell you. Man, I don't stop right in front of these folks and look at these folks calls. That shit on the phone. Yeah. I made Bentley call her. Like, call her. See what the fuck going on. Because of the probation. That's just a little bullshit. But the probation will try to hold you. Just about their money or whatever. So I already know that. I just said, I would just gave him a lawyer, look, 3-4 bank, $2,500. You know, he'll bring you.
You have 1 minute left.
He'll get you in the courtroom for $2,500. You know, that ain't shit. They don't even want that much. One lawyer had told me. I know. Yeah. So listen, I might have this son text you my information and stuff. You say you try to have in the morning. Yeah, I had a lawyer or whatever lawyer you choose. I don't have none. Well, I could just have somebody pull up on their son and bring their son the money. Then you see what I'm saying, or they can mom or daddy, because you know they probably know something about the shit. So I can just make anybody go get the money. I can make them pull up to the club, get the money from Ken or anything. Right now, you see what I'm saying? So that ain't no pressure. Shit, we don't know no lawyer though. Yeah, that's what I'm saying. You know my lawyer. So I know mine. I ain't got the number. Hit him. You just tell him. He already got my card and everything. He already got my card in his system and shit. So I ain't got the number. Just hit him. Like, go check on this number right here, and then go check on this name. And
Thank you for using Securus. Goodbye.
ZipRecruiter uses powerful matching technology to screen resumes and find the top candidates. Try for free at ZipRecruiter.
I'm can't say I just heard it either. Do you have a time reference you can point me to again? I'll listen to it again.
Very. 15:12 is what I'm being told.
Okay, let's play about right at 15 minutes, please.
Hello, this
Oh. Chris, can I listen to this? Council, I'm going to listen to it through the ear audio system. You're welcome to listen to it as well again.
It's gonna start at 15:04.
Go to the club, get the money from Ken or anything. Right now, you know that, so that ain't no pressure. Shit, we don't know no lawyer though. Yeah, you know what I'm saying? You know my lawyer. So I know mine. I ain't got the number. Hit him. I just tell him what. Yeah, he already got my card and everything. He already got my card and his system and shit. So I ain't got the number. Just hit him.
You can stop it. It
Go
does
check on
say, it
this
does say
number right
Brian.
here and go check.
So,
You're right. That's fine. We can stop it right before that portion.
all right.
I just.
Mr. Steele, any further? They're going to edit, or they're going to not play that. I do hear your name, at least what's represented to be Brian. So that will be excluded. Does anybody else have any specific objections as to any other period of that call from 000 to 15, about 15 minutes, 10 seconds or thereafter? Mr. Weinstein.
No, Your Honor.
Mr. Matthews.
No, Your Honor.
Misty Williams. All right, Mr. Botts, on behalf of Mr. Nichols. All right, Mr. Short.
No, Your Honor.
Okay, anything further, Mr. Steele? In regards to that section?
Not the part that you just ordered to be staged or not played.
It's not gonna be played.
Be clear that we're not just playing his name, but the fact he says, you know, my lawyer, and we'll stop where it says, before it says Brian. And then we'll play after that as well.
All right,
I don't know the relevance. And then it gets cut off. So I'm objecting to that.
to the relevance of, you know, my lawyer,
Yeah,
or that part of the tape?
what difference does that make?
Okay, state?
We believe that as a part of the RICO conspiracy, the fact that the leader is offering up his lawyer to pay for another co-conspirator to gang to get out of jail is relevant information. Who it is, that's fine, but the fact that he's offering up his lawyer for another co-conspirator is relevant.
Mr. Steele, anything else?
Yes, it was a conversation that got cut off. If you look at the records, or if the state bothers to look at the records, I did not have anything to do with Mr. Copeland ever. I don't know who represented Mr. Copeland, so I believe that it is irrelevant. It's just a conversation that was then cut off. So you don't get the entirety of the thought. So I do, if they're going to argue, they being the state's going to argue, oh, Mr. Williams is going to use his personal lawyer. That's not a true statement, so it's misleading. It's an incomplete, it's unfortunate, but I don't think anyone did it. But I think the securist cuts off at
15 minutes, yeah. The other thing is, I think that, well, the court heard there's some conversation prior to that, because we played the last 2 minutes in regards to representation. So I think that's what it's made in reference to, even though they don't complete the conversation. But Ms. Hilton, anything else?
That will go to weight, not admissibility. He can surely ask, if he chooses to ask Mr. Copeland any questions, did you ever get a lawyer? So he can ask Mr. Copeland that question.
Mr. Steele, anything else before I rule?
I just don't think it's needed to say my lawyer. That's what I'm objecting to. I don't mind the conversation about, I need a lawyer. I think Mr. Williams says, get any lawyer you want, something to that effect. It's not a quote. But I don't see the need to say, I have my lawyer, I have his business card, I can call my lawyer. I don't see how that is relevant. And then it gets cut off. So I don't know if that means what the state is saying is, oh, and then he's going to get Mr. Williams' personal lawyer for Mr. Copeland. That's not what it says.
and that would be certainly speculation.
That's
That
my,
would be speculation, but I think they get at least to play, based upon what they proffered so far. I think they get to play it as and also it's very limited as to what it can be said about it. Because unless Mr. Copeland, has some frame of reference, but
I don't disagree with that, but I would like to leave it after I need money for a lawyer. These are not quotes. But, they're discussing, I need money for a lawyer. I don't know any lawyer. A statement is made, we'll get any lawyer you want, and then just end it there, rather than I have my own lawyer and I have him on Rolodex or whatever I don't think Rolodex would use, but whatever those terms are, at that point I would end it. That's my request to the court. I also object.
let me see if the state has any
Your Honor,
further
relevant,
issues to that.
Your Honor, relevant evidence is any evidence that tends to prove an issue. We believe that the fact that the leader of the gang is offering up his lawyer to his co-conspirator is relevant for this jury to determine whether or not there is a RICO gang conspiracy. And so we believe that is relevant because the argument is relevant. It also comes in because it's a party opponent admission. This is the defendant Williams telling Mr. Copeland that I will provide. He said specifically what Mr. Copeland says is, I don't know any lawyers. And he said, you can call my lawyer, is what he actually says. So I think reading it in context, he's saying, okay, you don't know any, but I'll provide mine, or you can potentially use mine. Whether or not he used him or not, that is a question that can be asked of Mr. Copeland. But the fact that he was willing to offer up the lawyer is what is important, not the results of it.
Right. Sir.
I think this is a very bad point in our community if we are now going to say offering to get someone a lawyer is part of a RICO conspiracy. This is a probation revocation case on supposed non-compliance with community service. I know you haven't heard the whole.
And I haven't, sir.
That's what the recording before we started at 13:30. That's what it's about. Mr. Copeland says, and it basically mirrors what he said on the witness stand. He said, the police had me locked up. These are my words, trumped up charges because my probation officer didn't take out a warrant on me, but the supervisor was asked by the police to take out a warrant on me because of community service hours. I will be getting out on Friday. This is a Wednesday. I'll be getting out on a Friday, and I believe it's a Wednesday. I'll be getting out on Friday when I go to court, but I don't have a lawyer, so it gets continued for me to get a lawyer. So I'm held hostage basically by the way the courts are. So Mr. Williams is not part of any of that conversation. He then allegedly gets on the telephone and has a conversation, and that is explained to Mr. Williams as well. I go to court Friday, but I don't have a lawyer. To then say that it's part of a conspiracy to get a lawyer for someone going to court on a probation revocation case, I think is a bridge too far. To say you're going to get a lawyer, I don't have a problem with that. But to say I offered up my lawyer because that is symbolic of a crime, seems to me that if that type of evidence comes in courts, we are all in trouble, because that's what we want people to do. We want people to get lawyers. So I'm objecting to the state's playing that portion. I'm not objecting to the portion that Mr. Williams allegedly is on the phone and is offering to potentially help with a lawyer. I don't have a problem with that. If the state wants to then argue that's somehow part of a conspiracy, I'll argue against it. But to then go further and say, aha, and this is a crime organization and the lawyers are part of the criminal activity, I think that is under 403. It should never be said in any courtroom unless there's proof of it. That lawyers protect criminal parties.
Your Honor, the state never said, I don't even know where Mr. Steele got that last assertion from. The state said what is relevant is that he was willing to offer up his attorney to represent him. That is where it ends. And everything else Mr. Steele said is great for closing argument. But the relevance of it, it comes in, and then he can argue all of that, what he just said in closing.
It's relevant. It's more probative than prejudicial under 403, and I'm going to go ahead and I'll allow it. I'll give you a continuing objection, Mr. Steele, in that respect. Okay. All right. So what was the next thing you wanted to argue about, sir, or have me invite my attention to as to the first call? Is it the first call or another call?
This is this call, but it's going to be for
Okay.
all of the calls. To answer
Okay.
your question.
All right.
There's portions of it that are just conversation about what other people said. I'm just using example. Val, V-A-L, said that. Have 1 second.
In this call, Mr. Steele, or a different? Oh, I'm sorry. I don't. Your Honor, if you could ask, are we addressing the March 11th call?
I was gonna ask him for that clarification myself. Mr. Steele said it was this call and other calls, but he's making for example, and I think he mentions Val at that point in time, but I wanted to find out, is Val on the first call, second call?
I think this June 10th call, which may be the second call.
Yes, June 10th. That's the one at 2038, 4212, 10, 44. I'm sorry, 4 minutes, 12 seconds, 4 hours. Is it four? Is it hours, minutes?
It's 4 minutes and 12 seconds to 11 minutes and 10 seconds.
Okay, thank you.
But so can we just either close out or finish the March 11th? So we can
All right.
stay consistent, but the state will ask the court.
I was attempting to say, but it's going to be overarching, but I could do it individually. So on each call, there are conversations about what did someone else say. So Mr. Copeland allegedly, his voice is speaking with his girlfriend or significant other or the mother of his child. And he is saying, what did this person say? Well, this person said A, B, or C. I'm going to be objecting. I am objecting to anything that is hearsay. So for instance, in this call, Shannon said something. I'm not saying, Mr. Sharp and Mr. Botts can handle that for Mr. Stillwell, but I'm objecting to any third-party hearsay. They're not even on the call. I understand also that if Deshawn is not being called as a witness, which I believe she is not, I'm sorry, I shouldn't say the significant other of Mr. Copeland, I do not believe the state is going to call her. I don't know why her voice gets to be played on these recordings, unless she's somehow an exception to the hearsay rule. So I tell you that, Your Honor, because that is infected on each of these calls, because clearly there's another party on the call.
Another party that Mr. Copeland's talking to?
Who will not be testifying and who has not been classified so far as a supposed co-conspirator.
So, Your Honor, before we even get to these generalities, we can just talk about each individual call, because I think it becomes confusing and timestamped, so we can know what you're objecting to and the basis of your objection, because some of what Mr. Steele is referencing, there's exceptions to why this should come in. And so I think that we need to take call by call what is being objected to, so we can respond accordingly to that particular section.
You all have transcripts of these calls?
We do not have transcripts of the jail calls, but they're clear enough that you can hear what the issues are.
All right,
If
the
any.
challenge that we're gonna have is, without a transcript, you're gonna have to play these calls for me. Then each particular segment, unless you've identified that already, or this defense, Mr. Steele, I think you all are gonna have to identify that. Because what's gonna happen is, if it's played, we're gonna end up having this continual objection and potentially putting our jury out for periods of time to have me adjudicate that. So is it possible for you all to listen to the tapes, to the jail calls, and then flag those portions like you did for his interviews, to have me rule upon those? Because I understand what you're saying, Mr. Steele. It's a valid point. But what I don't want to do is, I want to minimize the the disruption from the jury. So if we have agreement, then, or if you need to just object, I'll say as earlier noted. So, yes, I think that would be a much better way to potentially present this.
I could have that, I didn't write down the timestamp, but I could do that.
So flag using the time.
Yes. And then you could tell me, for example, to go to, 12 minutes and 15 seconds, it's hearsay, it's not within any exception, or it's speculation, or, whatever. And I'll let the state respond, and I can rule, kind of similar to what I did with the audio videotape interviews. If that's the case, I think that would probably be a better use of our time.
And again, Your Honor, the portions that we sent an email yesterday are the portions we intend to play. So there's only 2 calls that we intend to play the entirety of it, but the other calls, we've broken down specifically the areas that we think are relevant. And so,
Okay, the first call is like 15 minutes.
so only the first and the 5th call are the full 15 minutes. The calls are 15 minutes. So only the first and the 5th, we intend to play the full calls. However, calls 2,
Is that the June 10th call at 2038?
yes, Sharon. So in the June 10th call, the only portions we intended to play is 4:12 through 11:10, and then picking back up again at 11:45 through 15:26.
All right.
And then for June 13th, the only portions we intend to play is 00 through 6:05.
That's still
And then-
a fair amount of time, though.
It is. So they definitely, but I just want to make sure that they're not listening to the whole tape and saying, I want to just keep the guides of what we intend to play, so defense knows the parameters that we intend to play when they're reviewing it to determine to determine what they're objecting to.
Okay. Ms. Steele, give you just a thought. I need to consult with Mr. Chamberlain just a second. How long do you think that will take? And I'll just ask you when we come back on the record, okay? All right. I'm just going to recess in place.
Hey, Dad. The pharmacy called. Sounds like you still haven't picked up your heart medication. Are you all right?
Don't let your
Okay. All right. Okay, folks. I'll just direct Mr. Adams and Mr. Steele, you all go ahead and do that at this point in time and then send what you feel you must to the state. And then we'll take it up either Monday, the 1st of July or Tuesday, the 2nd of July. As part, we left the Tuesday open anyways, the 2nd to complete whatever was not done. So I think that we could probably handle that fairly comfortably on that morning of the 2nd, Tuesday the 2nd. Set. Okay. All right. So let's just plan on taking that up Tuesday morning, the 2nd of July, when we start court. And we'll start probably 9:30 for an anticipated 10 o'clock start time. And we'll handle just the jail calls. Okay.
When will the defense have those objections to us? If we can have them today, would be great, but
Well, Mr. Adams said
before-
it'll be done in an hour, but you all think you could get it done in the next hour or so? I mean, because I'm gonna probably leave in probably about an hour. But tell me where you all are.
Would it be an impingement on anybody if we got it in writing by tomorrow morning? That'd be okay if it's not?
That's perfectly fine.
That's fine, Mr. Steele. Let's say by noon tomorrow, would that be sufficient?
No problem, yes.
Okay, all right. Okay, so we'll take those up on Tuesday, July the 2nd, 10 a.m. Okay, anything else we need to take up at this point in time?
Nothing from the station.
Anything from the defendants?
No, sir.
Okay. Monday, the 1st of July, as I mentioned earlier, we'll bring your clients over. They'll be here. I'd ask council to meet 8F jury room for Monday at 9 o'clock. All right? For the in-camera review.
And on that, Your Honor, again, and I know I said it, so I'm assuming that it's preserved, but Mr. Williams would like to be present.
Yeah, you told me that already. Do you have any additional case law other than the United States Sixth and Georgia Sixth Amendments?
Georgia's Article 1, Section 1, Paragraph 12. I believe Mr. Williams, I need him there to review. I assume we're getting a transcript. I don't know if that's what.
I'll cover that on Monday. Mr. Williams will be brought over, but the part that you all are here just for in camera, that's attorneys because of the privilege potential that is that may be discussed, or no, I said not discussed, identified, and you all as lawyers are of course subject to the rules of professional responsibility. Third parties or your clients and other people are not.
Okay, well, I oppose that objection.
And sir, if I have anything else, I will certainly reconsider that. But at this point in time, for that particular purpose, until we get through the in-camera review, I will, when the transcript is reviewed, the court's intention is to review everything for for Brady and/or impeachment. And then I will flag all those, and then anything else that you all wished for me to consider, you can mark, and then we can have a discussion about that.
Okay, and I'd like it done in open court as well, in Mr. Williams' presence, of course, and in open court.
Okay, I don't think he can do, until I identify it, Mr. Steele, and make rulings on it, he doesn't have the right to be present. You're the person that's present for him at that point in time because it covers privilege. It's just like if you had DFAX records, okay? You and Mr. Williams could not come to my chambers and review those records. You could, but he can't. Now, once I've ruled upon those, of course, I will copy whatever periods of the transcript, portions of the transcript that I believe are appropriate, and I will make other rulings in regards to sealing that particular portions which are not for any other review, and then you can take that to Mr. Williams, and all of you can talk about that.
I understand. I just.
I know you. I know you've made an objection as to that, as to your client's presence, but for the privilege or for the in-camera review, he doesn't have the right to be there. I respectfully disagree, but.
I understand that we are in disagreement, but I'd also like to then wait. An open courtroom, I believe that it should be done in open court as well, and that's under Article 1 and.
Okay.
The first in the.
I understand that. I agree with you about the open court. I understand about the open courtroom. I agree with you about the respective constitutional provisions. I disagree with you about the in-camera. That doesn't apply to an open courtroom. The in-camera review of these records. So we'll just, like I said, if you've got some case law, you got something for me to consider, I'll certainly look at it. But at this point, that's what my ruling will be in terms of your client's collectively presence. However, like I said, once the court makes those determinations as to which things are to be released to you, and I copy those transcripts for you, those portions or the transcript for you, then your clients will be here and you may take those portions and discuss those with your clients. Okay, and then we will have the rest of whatever we have in open court. Okay?
Understand the rule.
Okay, all right. Like I said, if you have some case law you want me to look at something, I'll certainly look at it. Because I
believe that under United States and Georgia Constitution and Presley, it's a voir dire issue, but I believe this should all be done in open court, not in a closed courtroom or closed chambers. jury room.
You are correct about anything else, but when you deal with when you're dealing with a matter of privilege and or depending upon the type of records you're reviewing, not everybody gets to see those. And that's where we disagree. That's not an open proceeding. That's a closed proceeding to decide whether or not what's going to be released. Again, I'm going to release to you what the court believes falls within the acceptable range categories of release. It may be the entire transcript. It might be portions of that transcript, but I'm going to listen to your argument about that. That you don't get an open courtroom for, because I have to make a determination of whether or not first you get it, and then whether or not what basis you get it for. Then once I release that, I make a ruling, which can certainly be reviewed at some point in time. Then I'm going to seal the rest of the record. I'm going to seal that particular ex parte because it will have some issues of attorney-client privilege. So that's why, or else I give you the entire transcript. It would be fine for me, but I think that that's the issue.
If an attorney-client privilege conversation was captured by the court reporter on a transcript with the court present, it can't be attorney-client privilege.
Well, that's for another body to resolve, not me. And you'll have to first decide whether or not those conversations were had. So once you take a look at the transcript, then we can have the conversation again, because that will affect whether I seal it or not.
That's fine. I'm just want to continuing. I've voiced it, so I think it's preserved. But
I think you've said it now 3 times. I think you've gotten your point across. But again, I'm going to tell you again, if you've got a case which says your clients can be present, I'll be more than happy to listen to you. I really will.
Well, my case is every case, but Penny, P-E-N-N-I-E versus State, Sammons, S-A-M-M-O-N-S versus State, Ward, W-A, Wade, W-A-D-E versus State, 1852. But the bottom line is, and they all say the same thing, at any critical stage of the proceedings, the criminally accused has a right to be present. I'm raising under federal as well as state constitution. I'm also raising an open courtroom, not a closed courtroom, under the right to public trial.
I understand that, sir, and I'll take a look at the cases you've cited, and that is part of what the court has to rule upon, whether or not it was in fact, or whether or not somebody else will rule upon, not me, I should say, whether or not it's a critical stage. But let me get through the review of the in-camera review first, and then we can have some other conversations. Okay?
No, I understand how it works. I just object. You're overruling it. I'm just
okay. All right.
Thank you.
State, you'll be able to as well join for those of you that were in there as well. I believe Ms. Hilton and Ms. Love for that same review. Okay. All right. Okay. All right, folks. I'll see you on Monday. All right. Enjoy the rest of your time.